Good afternoon, everyone, and a very warm welcome to this rapid response webinar, Legal Reflections on the ICJ's Climate Advisory Opinion and Beyond, hosted by the British Institute of International Comparative Law. My name is Ivan Alogna. I'm the Senior Research Fellow in Environmental Climate Change Law here at BCL and co-lead of the Climate Litigation Cluster within the IUCN Work Commission on Environmental Law, Climate Change Law Specialist Group. We meet at a historic moment. Just yesterday, the International Court of Justice delivered its much anticipated advisory opinion on climate change, a landmark in the evolution of international environmental law. Today's event is an opportunity to reflect on this important development and what it may mean for climate governance, international cooperation, and litigation. First, I would like to sincerely thank my co-conveners, Dr. Kate McKenzie, CEO and Director of the Climate Change Legal Initiative, C2LI, and my co-lead of the Climate Litigation Cluster, and Kirsten Hausler, Dorset Senior Research Fellow in Public International Law and Director of the Center for International Law at BCL. This event is organized in collaboration with C2LI and the Climate Litigation Cluster. In our discussion today, we'll also place the ICJ's opinion in conversation with two other recent and historic advisory opinions, one from the International Tribunal for the Law of the Sea, delivered in May last year, and another one from the Inter-American Court of Human Rights just earlier this month. And together, these three opinions represent an extraordinary moment of juridical cross-fertilization with far-reaching consequences for states, courts, civil society, and climate-affected communities worldwide. Let me also take this opportunity to warmly thank our distinguished speakers for accepting our invitation to share the reflection today, and all of you in the audience for joining us. There will be time at the end for a short Q&A, so please do not hesitate to share your questions in the Q&A box as the discussion unfolds. To guide us through the discussion, I am delighted to introduce our chair, Professor Malgosia Fitzmaurice, Professor of Public International Law at Queen Mary University of London. Professor Fitzmaurice is a globally recognized authority in international environmental law, the law of treaties, and indigenous people rights. She is a full member of the Institut de Droit International, and in 2021 was awarded a doctorate honoris causa from the University of Neuchâtel. She's also editor-in-chief of the Queen Mary Studies in International Law series and International Community Law Review, and served as counsel for the Marshall Islands in the advisory proceedings before the ICJ. It is a real honor to have her with us, and with that, I'm pleased to hand the floor to Professor Fitzmaurice.
Thank you very much, Ivano. I am honored to be asked to chair such a momentous workshop on the advisory opinions on climate change. So, as Ivano mentioned, yesterday, the ICJ delivered a long-awaited advisory opinion, and I would like to say thank you to you, Ivano, and to Christine and to Kate for coming up with this opportunity for all the stellar panelists today to share personal reflections on all the advisory opinions in the context. However, we thought that we would start with some reflections on yesterday's advisory opinion, and then since we have a certain panelists here like Monica and Christina, who were lucky enough to participate in all three advisory opinions, we will be eagerly awaited personal reflections in the context, as I said. So now a few housekeeping comments. Unfortunately, Professor Francesco Sindico will not join us or join us for a short period of time. And also Professor Niloufer Oral taped her presentation due to very pressing commitments in the Hague Academy. So I would like to now introduce the speakers and also in the sequence of appearance. So we would start with the presentation of Professor Niloufer Oral, which is pre-recorded. Then I would like to ask Monica Feria Tinta to share her views on very important and core issues of the advisory opinion of the ICJ. She is a barrister, but also a well-known scholar, and her latest publication is a very interesting and moving book, Barrister for Earth, which I recommend to everybody. And then I would ask to talk Professor Christina Voigt, who is Professor of Law at the University of Oslo, the chair of the IUCN World Commission on Environmental Law, and also member of the Compliance Committee of the Paris Agreement. Further, I would like to ask Professor Surya Deva, who is professor of Macquarie Law School and director of the Center for Environmental Law, and B&HR Access to Justice Lab at his university, and UN Special Rapporteur on the Right to Development. And finally, I would like Dr. Kate McKenzie, one of the sponsors and organizers of today's event, who is director of the Center for International Law at the who is director of the Climate Change Legal Initiative, co-lead of the Climate Litigation Cluster, IUCN WCEL, and Climate Change Law Specialist Group. So as I said, we have a stellar, really, group of experts, and I am only very happy and honored to be chairing and moderating such a wonderful discussion. So without further ado, I would like now to listen to Professor Nilofer Oral, who is director of the Center for International Law at the National University of Singapore, also a member of the International Law Commission and a member of the L'Institut de Droit International as well. So she is going to talk about ICJ advisory opinion and a link to advisory opinion of ITLOS, because in opinion of the ICJ, there were several places in which it was the ITLOS work and advisory opinion was treated in a rather extensive way. Thank you very much.
Greetings from The Hague. I'm delighted to be on this panel, but very sorry that I actually cannot be there with you in person and instead have sent this video. But without question, yesterday, the 23rd of July, was an absolutely monumental and historic day when the court delivered its powerful advisory opinion on the obligations of states in relation to climate change on a number of instruments. And I'm going to be speaking very briefly about the court's opinion on the issues relating to the law of the sea aspects. And it's really fantastic because, as we know, the Commission on Small Island States had requested an opinion on the obligations of states under the Law of the Sea Convention on pollution prevention and protection, preservation of the marine environment in relation to climate change from the International Tribunal from the Law of the Sea, which had delivered an opinion last May 2024. And so one of the questions was, for this opinion by, of course, we call it the World Court, were among the questions asked included the Law of the Sea Convention, whether the court would refer to the tribunal's opinion. Hopefully there would not be inconsistencies because the opinion of the tribunal was considered to be a very strong opinion, but solely on the relation of the Law of the Sea Convention, climate change, and the ocean. So understandably, the the opinion by the tribunal, also very long, 200 pages, very detailed. And so we can't expect that same level of detail from the court, which had to address many other issues. But I have to say, it is fantastic that the court's opinion really acknowledged, in fact, gave great strength to the opinion by ITLOS. And in that, and I'm just going to quote, the court was quite complimentary and stated, quote, ITLOS has developed a considerable body of jurisprudence on UNCLOS, both in contentious and advisory proceedings. Although the court is not obliged in the exercise of its judicial functions to model its own interpretation of UNCLOS on that of ITLOS, it considers that insofar as it is called upon to interpret the convention, it should ascribe great weight to the interpretation adopted by the tribunal. I cannot overstate the importance of this statement by the International Court of Justice. So in relation to the obligations for law of the sea, the opinion of the court cites ITLOS several times. It is clearly the main source, and I think for all those concerned about fragmentation, it's certainly not reflected in this opinion. So just very quickly, because we have limited time, so the court, like ITLOS, found that greenhouse gas emissions could constitute pollution within the meaning of Article 1 of UNCLOS. Second, also in relation to Article 192 of UNCLOS on protection and preservation of the marine environment, once again, citing the ITLOS opinion, the court stated, considering the seriousness of threat posed by climate change and in view of the high risk of serious and irreversible harm to the marine environment from anthropogenic greenhouse gas emissions, the standard of due diligence is to be applied when complying with the obligation to protect and preserve the marine environment is stringent. As ITLOS has recognized, the standard of due diligence has to be more severe for riskier activities. And I can tell you that throughout the opinion of the court, you will hear or read the word stringent over and over as the due diligence standard. Again, now, just very quickly, on the standard for obligations of state parties under Article 194 of UNCLOS to prevent, reduce, and control pollution. Again, the court, referring to the ITLOS opinion, stated that parties are under obligation to take all necessary measures, and of course that's actually the language of Article 194, but stating that this standard of due diligence is to be stringent. So, as I said at the beginning, the court's opinion did not go into the details of ITLOS, for example, on specific measures to be taken, including adaptation measures, but it has added a very strong confirmation to the tribunal's opinion on the law of the sea aspects and the responsibility of state parties in relation to climate change. And this includes also the very important duty to cooperate. And I'm sure, as my colleagues will talk about, throughout the opinion by the court, the duty to cooperate was really highlighted over and over and over again. And this, we know, is codified under Article 197 of UNCLOS, and that the court considers that this obligation is a continuing obligation and requires states to make ongoing efforts to formulate and elaborate rules, standards, and recommended practices and procedures. So in terms of these two, I think, really landmark decisions for the marine environment and climate change, the importance of the court's opinion cannot be overstated. But I really believe now that the ITLOS opinion will be the main reference for the Law of the Sea Convention, and that makes sense. After all, ITLOS is the tribunal under the convention. So I think I'm quite sure that the judges at the tribunal will also be very pleased. Now, last, I just wanted to say one thing that the ITLOS advisory opinion did not address, and that's because it wasn't really raised, was the question of sea level rise and its impact on maritime boundaries baselines. And in this case, the court directly addressed this issue, and that's because one of the members of the court was actually my co-chair at the International Law Commission on sea level rise in relation to international law, and we worked together on the law of the sea issues. So I have to say that I think we're very pleased with the reference and a very clear statement by the court that because one of the consequences of sea level rise raised questions about the impacts on baselines and whether those baselines would have to be changed, resurveyed, which would alter the maritime boundaries. And the court stating that it was aware of the final report of the study group and that the study group had reflected that there was a convergence of views among states across all regions in support of the absence of an obligation of state parties to UNCLOS to update charts or lists of geographical coordinates relating to their maritime zones once they have been duly established in conformity with UNCLOS. So that was the view that we had stated in our final report. The court considers that UNCLOS does not require state parties in the context of physical changes resulting from climate change related to sea level rise to update their charts or lists of geographical coordinates that show the baselines and outer limit lines of their maritime zones once they've been duly submitted in accordance with the convention. So this is very important because we just finished our sea level rise report. It was adopted by the commission and it will be discussed in the 6th committee. So this decision is going to have a very important impact on that as well. So I will stop here. There's so much more to say. I wish I were there with all of you, and I know you'll have a very rich discussion, but we will be talking about this opinion for many more months, maybe years to come. Thank you.
We had a very interesting and inspiring first presentation. And now I would like to ask Monica, if you are ready, to make your presentation. So let me introduce. Monica will talk about 5 points which are heart of the matter of the advisory opinion of the ICJ. A point on treaty interpretation lex specialis, human rights issue, erga omnes obligations, in the context of Inter-American Court, very interesting. Human-centric approach, again, comparison with Inter-American Court. And then the most complex, I think, part of the advisory opinion, points on state responsibility, attribution, causation, private parties, and also comments on legal consequences. Thank you very much. Monica, the floor is yours.
Thank you, Malgosia. This is an exciting discussion. First of all, I want to start by expressing, yes, my support to the view that this is really a landmark moment. The court gave us some years ago a very contradictory advisory opinion on nuclear weapons. Yesterday, the court gave us a lot of clarity when it came to how different regimes interact. And so I will start with sources. First of all, one of the contentious issues was is it really about lex specialis and that the Paris Agreement governs everything that has to do with climate at present, and therefore the rest, all the other sources of treaties shouldn't be actually being applied? And what the court said clearly is that there's no conflict. There's no conflict. The court is looking at international law as a whole harmonious fabric. And what Nullifer just explained in the case of the Convention on the Law of the Sea shows that harmonious approach. So the court didn't need to go into any lex specialis applicability because it simply there were different sources that were directly relevant, including customary international law, running alone, and there was no need to choose one. So that's the first point I wanted to make. Second, when it comes to human rights, it was, first of all, extremely interesting, the position that the court took. Well, the court recognized, number one, that this is an existential problem of planetary proportions. And that's a very strong statement. And also there was a self-inflicted problem. So when talking about human rights, the court acknowledged the fundamental right to a clean, healthy and sustainable environment, which is at the core of all the other rights that are relevant in this case. And this safeguarding the climate system itself was held to be an erga omnes obligation, which I think is as strong as the court could have gone. And you compare that with what the Inter-American Court of Human Rights did. Also, we're focusing on human rights and discussing these in similar terms. These are use coherence obligations and rights. So that obviously is going to have an impact in practical terms. But I think, you know, putting that emphasis is a game changer. We know that the European Court took a different approach when it came to the analysis of human rights. So it will be interesting to see what is going to be the impact now in the analysis of other different courts and tribunals when it comes to specific disputes that they may have to resolve. Now, one of the things that I have to highlight when it comes to human rights in this case is that nevertheless, we are still within parameters that are human-centric. And this is a very clear distinction with the advisory opinion from the Inter-American Court on Human Rights. The ICJ started with a very strong statement. The environment is foundational for human life, which is a very positive statement. But at the same time, it is within the human paradigm. What the Inter-American Court did was to step out from that human paradigm and to tell us that ultimately the climate crisis was, and the biodiversity crisis, etc., was about a wrong relationship with nature. And the Inter-American Court went as far as going through international law that was ecocentric, starting with General Assembly declarations like the World Charter, for example, for nature, where the intrinsic value of life, not just of human life, but all life, was asserted. That as a pivotal concept, ending with upholding the obligation of a state to protect nature. So the Inter-American Court of Human Rights really found that that is the key obligation, and to the extent that these relationships change, everything else will fall in place because all the crises come from this wrong relationship. So we haven't seen the ICJ going that far, yet I think it's interesting the clear statements that they have made in the area of human rights obligations. So one of the things, moving on towards issues of state responsibility, first, just a tiny point on primary obligations. I know that there is going to be someone else speaking about due diligence, but all what I like to say was very interesting for me to see the court engaging in a very interesting analysis of obligations of result and obligations of conduct. Clearly, the court said that there is no strict distinction sometimes. And that is good to see, because what has happened often is that the states take a very lax approach to obligations of conduct, as if it were something that, is completely discretionary. The court here, to pick up an example on the NDC, for example, concerning NDCs, it clearly said that it was not discretionary, that in fact is an obligation of result. That was quite, I think, important, and really making the point that it is far more complex, this relationship between obligations of result and obligations of conduct. On state responsibility, I think I'm delighted to see vindicated the position that our framework on state responsibility applies in the climate context very well. And the court said all the jurisprudence, all the case, all the analysis we have in general international law on state responsibility applies equally in the context of responsibility for breaches in the context of climate change. And why is that important? Because in the past, the states used to say, well, this is a global phenomenon. It's very hard to pin down a particular party. And you cannot sue a particular state for harms that are occurring miles away on another state far away. Is too complicated, it's too complex, and also concentrated on issues of causation. This is all about causation, you cannot prove it. Well, the court said that it didn't agree with that. It clearly looked at the rules of attribution. And when looking at that, it held that, yes, there is climate change, obviously is caused by various factors, but when you analyze the state responsibility, you look at the primary obligation. What was the specific obligation of the state? And if the state breached that obligation, then state responsibility arises from that as a secondary rule, not from emissions, volatile in the air, but from that, analyzing that specific primary rule that has been breached. And so that is obviously separate from issues of causation that has to do with damages, and is a different assessment, and it has to be done on a case-by-case basis. But one of the points that the court accepted, is the possibility of being responsible for transboundary harm. And I think this is absolutely important. We saw recently cases like the case of Surya, in a context of domestic dispute resolution. But, this is the example where basically, I don't know, a potential island state in one side of the world could sue a powerful state that is breaching primary obligations for what this lack of action or other breaches may contribute to a particular harm taking place in that island. So this is opening the door for a lot of reconceiving what is going on at the level of state responsibility. So transboundary is quite a key concept there. Private parties. I found also that was very interesting the emphasis that the court made when stating that the states are responsible to regulate the activities of private parties within their jurisdiction and control. And this is really a critical point, because as we know, private parties are responsible for emissions, historical emissions and emissions currently. And so it's crucial how the states now may have to reassess its obligations in that context. Finally, legal consequences. Well, this is a very rich and important area. ITLOS didn't deal with legal consequences. The Inter-American Court has a very well-established jurisprudence when it comes to legal consequences, including in the context of environmental claims. And I think here there is a similar approach by the ICJ. First of all, the principle of cessation. Cessation clearly in the context of understanding mitigation falls within it. If there is an ongoing issue, an ongoing violation, then cessation will mean you have to stop with that wrongful act. And there were many examples that were given. One of them being if, for example, that may imply to stop something, a wrongful act, withdrawing legislation or administrative acts. I don't know if you have given licenses for something that on assessment is in violations of your obligations under international law in this context, then that maybe have to be withdrawn. So these are specific cessation measures. Second was also the obligation of restitution. And restitution is, by way of example, it could be if there has been a destruction of infrastructure and there's a party that is responsible eventually for that, then it will have to restitute that for allowing for the rebuild of those of that infrastructure, etc., as an example. Also, it was clear that in some scenarios this is not possible, and when that happens, there may be a need for compensation, and that was obviously to be assessed on a case-by-case basis. But all these legal consequences that are part of state responsibility rules under general international law, the court held that they applied very well in this context. Finally, issues of satisfaction were also held to be possible, and it will depend also on the character or the nature of the claim itself. So what we are seeing here is really a proper understanding now of the whole regime of state responsibility, and the court really considering that that can happen in the context of harm that usually is of a transboundary nature. So it's going to be, I think, a massive impact when it comes to litigation if we get to that. I will stop there. Thank you.
Thank you very much, Monica, for raising all these really very important issues, and also observing that international environmental law, climate change are firmly embedded in general international law. And this is something not only human rights law, but general international law. And I think this is one of the very important points of this advisory opinion, because very often environmental lawyers feel that they're doing niche work, and it's sometimes pointed out by my colleagues, so Malgosia is doing niche, she is niche. But this is not niche, this is general international law. So thank you very much for that. And also thank you for this erga omnes obligations, and mentioning that Inter-American Court use preservation of the environment was named Jus Cogens obligation. And this is something which is also general international law, and I spent quite a lot of time thinking about it myself in light of International Law Commission, Jus Cogens work, and very stringent parameters of the new norm of Jus Cogens emerging. So I am still thinking how to put it in a context of general international law, the statement of the Inter-American Court. But I find it very interesting and worth further study, as well as the stand of Inter-American Court on intergenerational equity. I think that was really a very interesting point they made, and quite extensive. But now enough of my comments, and I would invite Christina to comment on her impressions of the ICJ opinion in the context. Thank you very much, and the floor is yours.
Thank you so much, Malgosia. Well, first of all, many thanks to Ivano and Kristen and the team from BICL for organizing this immediate rapid response exchange of views. I just earlier today, I came back from The Hague, still digesting and working through the impressions from yesterday when I was actually sitting next to Nilofer in the Great Hall of Justice, listening to the president reading out excerpts from the opinion. And it was, as Nilofer said, it was a historical moment, which was obvious to everyone in the room, because occasionally from time to time, you could hear gasps from different people in the room, being surprised, being touched by what they heard from this court. The expectations were sky high, as we all know, but what the court delivered is something that will stay with us and pave the way for climate law, for climate justice, and most likely also for climate litigation for many years to come. Now, I heard a good friend of mine saying this morning that what the ICJ, or with this opinion, the ICJ really became the world court. And I think that really struck a chord with me as well, because this is what many felt, that the ICJ heard the requests by the General Assembly and delivered on the two very pertinent and broad questions put to it. Now, Malgosia, you asked me to share some of my main points and reflections. Now, a lot of that aligns, of course, with what we just heard from Nilofer on the reference to the Law of the Sea and the International Tribunal Law of the Sea, ITLOS, as well as the 5 points that Monica raised. So I'm trying to react to what I heard and navigate, and maybe trying to find some additional points, but there's a little bit of overlap. But I think what struck me the most was that the ICJ, as a court with general competence, of course, had the possibility to look into the entire canvas of international law, and it did. It looked at the treaties and, of course, customary norms that it considered particularly relevant. And in the beginning, when the president started to read, it really explained why it considered several treaties in international environmental law, as well as human rights treaties, as well as law of the sea, and several customary norms relevant in this context. But by doing so, what the court delivered was a really consistent and harmonious view of international law and how these different international norms, the different sources, relate to each other. And the court many times used the term of mutually supportive, right? It rejected the lex specialis arguments on everywhere it was raised, and it was raised many times if you listened to the oral proceedings last year in December. But the court outrightly rejected it in all contexts, and would repeat many times that these different treaties, be it climate treaties, CBD, Convention on Biological Diversity, the ozone treaties, law of the sea, human rights, are mutually supportive. They inform each other. They're not on any conflicting relationship. So I think this is a very important aspect, that there is no hierarchy in international law, but we have a huge canvas now of legal obligations for states to drastically and rapidly reduce greenhouse gas emissions. And most, if not all, of these obligations have that standard of due diligence, which the court repeatedly qualified as being stringent, something that we've heard both from ITLOS, but also from the Inter-American Court on Human Rights, which established an enhanced due diligence standard, but something that goes above and beyond the due diligence standard that we had so far in international law, to a raised, heightened stringent due diligence standard in the light of the risk, in the light of the urgency to act, in the light of the impacts that would happen, is a really important aspect, and it is consistent throughout the canvas of international law that the ICJ provided to us. And I think you, Malgosia, or Ivano mentioned in the beginning that I had the privilege to attend all three and was involved in all three advisory processes as legal counsel of the IUCN, and it was something that we were worried about, that different courts may establish different standards, but this is not what happened. We put a lot of emphasis on the same standard in our submissions to the three different courts, but it's exactly what the court then also found. They really adhered to similar considerations and elements by defining a due diligence. Now, another point that I thought was really interesting that the ICJ did was to establish the 1.5 degrees centigrade threshold as legally binding. And it did not base this on the Paris Agreement alone, where it probably wouldn't be so easy to establish it as a legally binding threshold, but it based it on later decisions by the governing body of the Paris Agreement, the CMA. And it considered these decisions by the CMA as subsequent agreements in the context of the Vienna Convention on the Law of Treaties, and thereby as establishing binding subsequent rules on the parties. That was surprising to many. I think in the room, I heard that was a moment when I heard many gasps, but it was a really interesting and very important finding by the court, because that, of course, the 1.5 degree threshold, informed many of the other obligations under human rights law, under law of the sea, and so forth, as an international standard, which states have to take into account by exercising stringent due diligence. A third aspect, and I think Monica briefly touched upon this. Now, the ICJ was now the first court who actually was asked to interpret parts of the climate treaties, in particular the Paris Agreement. As you all know, a very difficult negotiation, a lot of ambiguous language in the Paris Agreement, but the court went quite deep into interpreting the obligations of conduct surrounding nationally determined contributions, so NDCs. It was clear that communicating an NDC is an obligation of result. I think that has always been clear. As the chair of the compliance or member of the compliance committee, we have our work on that to do. But what the court did was it established that there is an obligation of conduct when it comes to preparing the NDC. And the conduct is defined by due diligence, where parties have to align their NDC with the 1.5 degree target, as well as reflect progression, highest possible ambition, and reflect common but differentiated responsibilities and respective capabilities as elements of due diligence under the Paris Agreement. That was new, that was very progressive and very important finding, because the court very explicitly said that NDCs are not just voluntary and lie in the discretion of states. I think this is particularly impactful and important. It also said that the achievement, the implementation of the NDC, which many thought would lie outside the Paris Agreement, is also an obligation of conduct. Parties do have to take appropriate domestic implementation measures to achieve their NDC. Now, the fourth point that I'd like to highlight is on international customary law. Monica addressed it already to a certain extent. I think that was the joker in the opinion, where many were wary about what the court would say. But with respect to the obligation to prevent significant harm to other states and to areas beyond national jurisdiction, the court was crystal clear that this obligation, customary law obligation, applies to climate change, despite the cumulative nature of climate change. There is no question. And the court established also here a stringent standard of due diligence as due diligence. Same with cooperation. Jennifer already talked about it. Cooperation as a customary international obligation was something that the court put very, very centrally in its findings. Now, with regard to diligence, and that's my last point, Malgosia, it was very interesting to see how specific the court would get on what due diligence obligations contain. It went even so far to speak explicitly about fossil fuel production, consumption, licensing, and subsidies as something that may be contradictory to that stringent level of due diligence that is now expected of every single state to do its utmost, to do as good as it can or as well as it can to reduce greenhouse gas emissions as quickly as possible. And of course, also the violation of a due diligence obligation, of a conduct obligation, is an internationally wrongful act and does give rise to state responsibility. As you just said, Malgosia, we are squarely locked into the general public international law field. And Monica spoke about the application of state responsibility, but very importantly, that also applies to a violation of an obligation of conduct of a due diligence obligation. I stop here. There is much more to unwrap, but I'm thinking we will. I expect we will come back to it in the discussions. Thanks to you, and back to you, Malgosia.
Thank you so much, Christina. It's really lovely to hear your personal reflections and also further sort of elucidation and clarification on what the court said on the Paris Agreement, because it's quite complicated. And I don't think the court took any shortcuts in describing the obligations under the Paris Agreement. I think it was quite commendable of the court, which is a general court, to sort of delve deeply into climate change obligation and under a very complex, well, agreement. Let's face it, it's not an easy agreement. And again, thank you very much, Christina, for bringing the obligations of conduct and result, because it's a notoriously difficult area of state responsibility and international law. And as the court said, it's a gray area. I think we always tend to make sharp divisions because we want to know where we stand, but it's not always so clear in general international law and climate change law and environmental law. So thank you very much. It really links very well with what Monica said. And now we are moving on to Surya. Hello, Surya, who is going to spend some time talking about the principle of cooperation, which also form quite a big part of the customary law obligation in the advisory opinion of the ICJ, and also the common but differentiated responsibilities and respective capabilities. And let's see if we have time. Maybe we will talk about some gaps in the advisory opinion. But the floor is yours, Surya. Thank you.
Thank you, Malgosia, and thank you to Ivano as well for organizing and the invitation. Let me start by echoing my colleagues, expressing the sentiment in terms of the historic nature of this advisory opinion, because it was not given that the ICJ advisory opinion is going to end up so ambitious. It was not given. And it's all relative, because we already had an advisory opinion of the Inter-American Court, which, as I will try to compare, and Monica did as well, which was quite path-breaking. So if you look at in that particular context, the ICJ has not disappointed generally. So in terms of the duty of international cooperation, which is absolutely vital to deal with the climate change crisis in which we are, the court traces it both under the treaty law as well as customary international law. And I think they don't merely articulate it at a normative level. They also go into specific aspects of it in terms of financial assistance, the technology transfer, and all those particular aspects. And I think that was really good. At the same time, I would have liked the court to go a little deeper into the details of what it actually means in practice. Because we already know how much is needed in terms of technology transfer, what obligations are needed. Because if we have to move away from a fossil fuel economy, it will not happen automatically. Developed countries and corporations who have the technology for a just transition, for a zero carbon economy, they have to provide those technologies and resources. And unless that is made available to developing countries in the global south, the transition will not happen. It will happen on paper, it will not happen in practice. And I think that's where I felt that the court, perhaps I would have liked to see more deeper dive into the contours of those international cooperation elements, whether it's about financial assistance, because we already know loss and damage fund. We don't even have 1% of what is needed. So how this obligation is going to result in the actual assistance in terms of technical know-how, in terms of technological innovation, in terms of financial assistance, I think that is yet to be seen. And I think that is where the comparison with the Inter-American Court of Human Rights advisory opinion becomes quite telling. Because that opinion also deals with the international cooperation element, but it goes a little deeper into it. It talks about international solidarity. It talks about various aspects of cooperation. It's not merely international cooperation, it is also bilateral cooperation that can unfold. So I think those aspects are very crucial. And is also and also from the perspective of my mandate on right to development, because if we talk about the duty of cooperation, one key declaration is the Right to Development Declaration of 1986. And the court does not cite it. The court cites several other declarations. But I think one of the most prominent declarations which articulates and put focus on international cooperation is the 1986 Declaration on Right to Development. And the court, maybe perhaps consciously, and I will explain later why I'm saying consciously, did not cite this particular declaration. Now, if I can briefly move on to the second aspect, which is the principle of CBDR, as you mentioned, Malgosia. And the court articulates a number of general principles, and CBDR is one of those principles. I would say it's not merely a general principle, I will say it's an overarching principle. It's an overarching in the sense that all the obligations that the court is trying to articulate in terms of mitigation, adaptation, or even remediation, if there's a breach of these obligations, CBDR will have a role to play, that what mitigation should look like. It will have also a role to play in terms of NDCs that Christina talked about. It will also have a role to play in terms of what stringent due diligence or enhanced due diligence should look like in practice. So I think the court attention to this as one of the general principles was a positive step. It's very much needed in relation to climate change. But again, if you compare it in the overall context, I think I was a bit disappointed. The sustainable development features only in one paragraph, if I did not miss it. So it's a very brief reference to that. I mean, sustainable development is at the core of climate change crisis that we are dealing with. And I think that's where, again, the Inter-American Court talks about transformation, that we need to really move into a transition to a new model of development that we need, and merely mitigation and adaptation may not be enough. So I think those aspects are very good. ICJ also very interestingly mentions that CBDR is merely a general principle. It does not create any new obligations. I still need to read the separate opinion from the judges, and I believe in one of those opinions there is a disagreement and on that particular point of CBDR. So I think I still need to unpack that. So I think it's a good starting point that the court grapples with these particular principles. If I see the ICJ advisory opinion in isolation, on these two particular points, Malgosia, both on international cooperation and CBDR, it looks quite good. But if I compare the ICJ advisory opinion in the context of the Inter-American Court of Human Rights opinion, it doesn't look great, I'll be very honest, because the Inter-American Court went further ahead in terms of articulating, and I think Inter-American Court, I would say, is closer to the ground reality in terms of what needs to happen. It is representing the voices of what needs to happen in the global south, if I can say that. And I think the ICJ, the consensus opinion, I think is bit at 40,000 feet, and it's not able to grapple with the realities that what needs to change in terms of that cooperation. If I may quickly mention 3 or 4 points, and I will stop with that. And these 3 or 4 quick points are about, I would say, missed opportunities for the ICJ. I mean, we are celebrating ICJ's advisory opinion, and I don't want to be seen as not celebrating, but I also want to acknowledge where the missed opportunities are. One is the polluter pays principle. The ICJ discusses, but then dismisses that polluter pays principle is not one of the general principles that the court is going to apply. And I was disappointed because this is a very well-established principle of international environmental law, at least. So if the court is invoking all the international law corpus, then how can you say the polluter pays principle is not part of it? And I think I was feeling a bit strange there. Then, of course, in relation to the rights of the future generations, again, there's disappointment there. It talks about very briefly about the interest of the future generations. It talks about intergenerational equity, but the rights of the future generation should have been there. I mean, the Pact for the Future last year already goes about that. And I think ICJ does not talk enough about disproportionate and differentiated impacts, both on people as well as on states. There is an interesting paragraph where the court talks about this spectrum. I think it's paragraph 150, if I remember correctly, that there are those developed countries that have caused significant greenhouse gas emissions, and the other spectrum is those who have caused little, and then talks about somewhere in between there are other countries. It's an interesting analogy. But when it comes to the impact on small island states and all that, the court dismisses that no, some states cannot be more exposed to this and they cannot have higher remediation responsibilities of that. So I find a bit puzzled there. I think we need to unpack more some of these nuances, but I will stop here for now. Thank you very much for the opportunity.
Thank you very much, Surya. And I must say that I agree with a lot what you said, and they were my thoughts as well. First of all, thank you for in very clear insight in principle of cooperation, which is definitely one of the founding principles of climate change law, international environmental law, and CBDR. And when we look how it is now relied on, we can see what a long way this principle has gone from Principle 7 of the Rio Declaration, how basically it became a pillar on which international environmental law is based now, and international climate change law. I agree with PPP, the polluter pays principle. I think that this is also a founding principle of international environmental law in general, and to substantiate what we are saying in the International Law Commission project on general principles of law, that was PPP mentioned by the special rapporteur as well-established general principle in international environmental law and general international law. So I think that the court should have spent a little bit more, put a little bit more attention to explaining, because this principle is very much connected to also how the state behaves in relation to private individuals. So no subsidies, etc. This is the basis of it, as we know. So thank you very much for your insightful comments. And now, Kate, please, the floor is yours, and please elucidate more on the due diligence principle in advisory opinions. Thank you very much.
Thank you, Malgosia, so much. And as you all have heard mentioned many times, due diligence already. I'll focus on that. And I've followed all three of these advisory opinions really from a due diligence lens. Due diligence was mentioned no less than 80 times in this advisory opinion alone. So it's in every section. And I'll just focus on some of the most relevant portions. Now, I do have to also sort of give you a sense of my perspective. My perspective really comes also from a litigation perspective, right? And so how will this and the other advisory opinions really potentially contribute to the further development of litigation strategies, particularly also in domestic courts is of interest to me and my organization. Now, the ICJ connected, as everyone that's spoken has already said, Monica mentioned this, Christina mentioned this, of course, that there are so many different areas of international law that the court really connected here and gave us a really harmonized definition or description really of what due diligence is. And crucially, I think, that the standard of due diligence that is required when it comes to climate change and addressing climate change is stringent, right? That is similar language that we saw in the ITLOS advisory opinion as well. Monica and Christina also, and Malgosia, you of course also then mentioned that the court didn't shy away from making sure that it was clear that obligations of conduct and some obligations of result require a due diligence to be applied. I'll start with a unanimous declaration by the court. The court unanimously found that states have the duty to prevent significant harm to the environment by acting with due diligence and to use all means at their disposal to prevent activities carried out within their jurisdiction and control. That is important too, right? Because we get to the private actors there, from causing significant harm to the climate system and other parts of the environment in accordance with their common but differentiated responsibilities and respective capabilities, linking due diligence also to CBDR. Now, the court gave us kind of a baseline outline of due diligence early on, starting in paragraph 135, where the court said that the duty to prevent significant harm to the environment is an obligation to act with due diligence. It is not an obligation to succeed no matter what, but it is an obligation to employ all means reasonably available to them so as to prevent harm as far as possible. So there's lots of sort of parameters around the obligation, but it gets really, really clear. It goes into some detail on specific requirements, including, for example, that states must take, to the best of their ability, appropriate and necessary precautionary measures, which take into account scientific and technological information. That's a requirement to have and gain knowledge, as well as, of course, relevant rules and international standards, which then, of course, vary dependent on the state's respective capabilities. And here, this reference to international rules and standards is, I think, also important, and the court goes into some detail later on, mentioning that COP decisions, for example, are part of this library of information and rules and conduct that need to be taken into account as we consider what is due diligence. The court also, of course, found that due diligence must be assessed on a case-by-case basis, and this is where the future litigation perspective then comes in. And the court courts have to determine whether due diligence is reasonable under specific circumstances. But this does not, as I mentioned just now, on international or sort of standards and rules, the case-by-case analysis of due diligence does not exclude an identification of a minimum required standard of conduct, for example. And then, of course, that would be depending on the overall character of the risk that is part of the environment in question. Here, the court said this is particularly important in respect of climate change because of the specific character of the risk of significant harm to the climate system, and that is indisputably established, referencing the IPCC. Now, here's where we start getting lots and lots of references to the stringency of due diligence, and that as concerns climate change, a heightened degree of vigilance and prevention is required. The standard of due diligence for preventing significant harm to the climate system is stringent. This is mentioned now over and over again, and is also the same language, that stringency, that was used in the ITLOS advisory opinion. Due diligence, the court was clear on. It entails not only the adoption of appropriate rules and measures, but also a certain level of vigilance in their enforcement of these measures, right? So that kind of reaches in, that is the court reaching into domestic situations a little bit more. Not only do you have this obligation to adopt these measures, but you must be vigilant in enforcing them as well. Now, due diligence that is required of states, it means that they must use all means at their disposal with, this is crucial, with a view to fulfilling their international obligations. Those are then the primary obligations, right? One of them being, of course, the temperature goal being a really, really clear goal that we must meet. Crucially, compliance with Paris Agreement obligations of conduct, where there are so many in the Paris Agreement, is assessed on whether the party in question exercised due diligence and employed their best efforts by using the means at its disposal in the performance of its obligations. And it's already been mentioned, but the court specifically went into NDCs here. So as it comes to NDCs, we've always talked about discretion, right? They're nationally determined, but this is also something that Monica mentioned earlier, that discretion in preparing the NDCs is not unlimited. It is not unfettered. There is definitely a limit on the exercise of the due diligence required there, and on the discretion. Again, the standard of due diligence to be applied in preparing the NDCs is stringent. That's in paragraph 246. The court is clear that the due diligence, of course, varies depending on national circumstances and capacity, linking back to CBDR. But in the implementation of the NDCs and those domestic mitigation measures, compliance is assessed on due diligence. And here the court references ITLOS again, saying that the obligations of due diligence is particularly relevant in situations in which the activities in questions are mostly carried out by private persons or entities. Again, linking us to those private actors. Let's see, we've got lots of references of the stringency, including that the level of due diligence that attaches to obligations, again, to pursue domestic mitigation measures is stringent. Same applies to adaptation measures as well. Fulfillment of adaptation obligations are again, the standard of due diligence is applied here. The court reiterates that while the scope and content of measures that are contained in their NDCs can vary according to the means available to the party and their capabilities, parties do not enjoy unfettered discretion in the preparation of their NDCs. Each party, this is paragraph 270, each party has a due diligence obligation to do its utmost to ensure that the NDCs it puts forward represent its highest possible ambition in order to realize the objectives of the agreement. That really gives us a high standard of due diligence. The court is clear that risk is a really important element of due diligence, telling us that the degree of a given risk of harm is always an important element for the application of the due diligence standard. The higher the probability of serious harm, the higher the seriousness of the possibility harm, the more demanding the requirements are, of course. I'm not going to take up too much more time, so we have time for actually talking and getting some questions from folks. But I think it's really important when we're looking at private actors here that due diligence requires states to use all means at their disposal in order to avoid activities which take place in their territory or under their jurisdiction. And here we really do get into those domestic measures. States must, according to the court, put in place a national system, including legislation, administrative procedures, and an enforcement mechanism necessary to regulate the activities in question and exercise an adequate vigilance to make sure that the system functions efficiently with a view to achieving the intended objectives. And that is a direct quote from the ITLOS advisory opinion. So here we again have harmonization across advisory opinions. Another reference to appropriate rules and measures must include or can include regulatory mitigation measures that are designed, again, to achieve deep and rapid and sustained reduction in greenhouse gases. Final comments on the private actors, where the court tells us that rules and measures that are implemented must regulate the conduct of public and private operators within the state. Christina made mention to fossil fuels. The interesting language here is that in the context of due diligence and state responsibility and wrongful acts, the failure, this is a quote from the opinion again, failure of a state to take appropriate action to protect the climate system from greenhouse gas emissions, including through fossil fuel production, fossil fuel consumption, the granting of fossil fuel exploration licenses, or provisions of fossil fuel subsidies, may constitute an internationally wrongful act attributable to the state. I think that is really, really crucial. So a state may be responsible where it has, for example, failed to exercise due diligence by not taking the necessary regulatory or legislative measures to limit the emissions that are caused by private actors under its jurisdiction. It's interesting that this advisory opinion opens much more clearly, in my view, a path to hold states accountable for private actors within their territories and for failing to adequately regulate them. And so I think from a litigation perspective, compliance with an assessment of the sufficiency of due diligence that a state employs can only be determined on a case-by-case basis, right? So that means that courts are ultimately going to be the arbiters of this. More litigation is going to have to test out really what are the limits of due diligence. And crucially, courts now will be able to use this advisory opinion in concert with the other two to really have a harmonized approach to due diligence that really says it is a stringent level standard and it requires heightened due diligence because of the heightened seriousness. And I think it's going to be particularly interesting to see how this will be used in domestic courts. I'll stop there.
Thank you very much, Kate. It's really, I think, incredibly interesting how the due diligence is sort of also taking a central place in dealing with climate change and environmental law. And I think this advisory opinion of the ICJ further specified what is understood under due diligence and stringent due diligence. On the other hand, I am trying to visualize how this general guidelines or pronouncements of the court are going to be applied in concreto, as they say, in particular situations. I think this will be a very interesting point, and especially in relation of application of due diligence towards private actors. I think this is a very complex area, and I think it's still going to be developed through litigation, I think. But thank you very much for your very, very insightful comments. Thank you very much. So now I think I see that Professor Syndico is here. So maybe Francesco, could you take the floor and share with us your personal reflections on advisory opinions in plural? What do you think?
Thank you very much, Malgosia, and apologize both to the other speakers and to the participants for arriving late at the party. I just want to make 3 points because we're late and there are a lot of questions and so forth. One is a specific aspect of the celebration that I think we really need to make today. The second is one chain of normative highlights that from the limited, not even reading, just what I heard yesterday, I would like to make. And third, two implications going forward. The first thing is that we do need to celebrate this. We live in a world where there's so much bad news around us. There's so much climate anxiety, all sort of things. Let's stop and actually celebrate this. And in particular, let's remember who brought this. This was not academics. This was not practitioners. This was not politicians. This was not any of that. This was young people from the other side of the world, from where I am, from Vanuatu. This is an inspiration for all of our law students, for all of young people around the world. So I really want to stop and celebrate them. Obviously, this can only happen if they're given resources, space, and voices, mentoring, and so forth. That's the first thing I want to share with you. The second is the chain of normative highlights. I know some of you already mentioned this. First, the court said there's a climate collapse. There's an existential threat to the planet. We all know this, but it's good that the court reminded us. And that the goal, the normative goal, is 1.5, not 2%. Forget about 2%. It's 1.5. Two, the level of due diligence is based on the risk of harm, as Kate already said. This links us back to the science. And we are at a climate collapse. We're not just at any climate change. We're at collapse. Three, if we are at collapse, keeping fossil fuel subsidies is just ridiculous. Not from a political perspective, not from a socioeconomic perspective, not from a normative perspective, under certain circumstances, I agree. But this is huge. Until yesterday, this was not clear under international law. Today, it is clear. And fourth, this is a due diligence obligation, which is an erga omnes obligation. Crazy Latin words, huge practical implications from an interstate dispute. So this is the chain of normative highlights that I wanted to share with you. Third and last, the implications going forward. We were discussing this with colleagues in C2LI and also friends yesterday. Actually, what this does, which wasn't there 2 days ago, but it is there today, the advisory opinion is a normative shield against populism and against false economic arguments against renewables. If a government wants to do a good thing, the right thing, moving towards a just transition, moving towards renewables, it now can say that it's the legal thing to do. It's the right thing to do, not just from a justice perspective, but it's because it's the law. That wasn't there 2 days ago. So there's a huge development. The last thing is, let's also be honest. And I think the president finished very well yesterday by reminding us the limited role of international law and the limited awareness of international law around this room. We have 237 participants, 10 of us here. We all live in our own bubble of international law. We think this is amazing. Go have a look at the newspapers today. I haven't been able to find one news on major UK newspapers about what happened yesterday. Now, I don't want to criticize this, but let's not forget that this is also the world we live in. A world that has a 30-second memory, where international law is after gossip of Love Island kind of stuff. Now, this is not a bad, maybe it's a good thing. Maybe we can work in silence in the background, and who cares about that? But let's remember that international law is part of a puzzle. As the president said, this is a socio-economic challenge. It's about awareness. It's about politics. It's about science. It's about everything. Let's celebrate today, especially the young people who started and all of us who had a bit of a role in it. But also let's realize that there's a world out there that has no clue what an AO is, have no idea what due diligence even means. And again, I'm not saying that's a bad thing, but let's also be aware of that. I'll stop there, Malgosia, but thank you so much for giving me a few minutes.
Thank you very much, Francesco. We all need good news, and thank you very much for being positive about it. I have the same feeling. I was actually quite impressed by this advisory opinion, and I did not expect that it would be so extensive and over-encompassing, that the court really took the trouble to look into it and to standard of due diligence. And also I agree that it's not only law, right? Law is limited in this area. And I also would like to emphasize that the court really relied on science. And this is something which we also have to celebrate, because many judges just don't like science, but they relied on science. And I think this is the continuation of what started in the whaling in Antarctic case, when the court relied very heavily on the opinions of experts in relation to science. So I think this is like continuation of a good practice of the ICJ. So now I think that we have just few minutes left for questions, and we have very interesting questions. I will read them out very quickly, and anybody from the panel is invited to answer them. So, question from Marcus Gering from Cambridge. Thank you for an amazing panel. The landmark advisory opinions mean that we all need to teach climate law differently. What is the first change that you will make to your teaching or advocacy? The question. Who would like to start on it? Christina, would you like to start maybe?
That's an interesting question, Marcus. But to be honest, I've taught pretty much along those lines. What would I change? Maybe delving deeper into the different criteria of due diligence, what makes it stringent or heightened or enhanced. I think that is something that students deserve to grasp in its depth and breadth. I think that would be my change. But I think the very important message is that climate law goes beyond the climate treaties. It is a whole package of international law, and that should make it really interesting for law students. Back to you, Malgosia.
Very much. I have a second question of Justice Luc Lavruysen, President of the Constitutional Court of Belgium. The question is about state liability for climate damage. If such liability derives from customary international law and involves obligations erga omnes, is there any legal avenue through which a country like small island states could bring a case against the United States before the International Court of Justice, despite the fact that the US has not fully recognized the court's jurisdiction? So I wonder who would like to tackle this question. Francesco, maybe?
I'm happy to go it and risk it. Anyway, I've been to a specific country earlier this year, so I feel this is where international law and international politics clashes. So, you know, it's a great question, but let's be honest, it's more political than legal, in my opinion. Now, there are better people than me to understand all the nuts and bolts and the procedures of ICJ, how to get in, how to get out, and so forth. So I'll leave it to them. But what I do think is that the erga omnes obligations has a magical effect in a way. I mean, how in the earth has Gambia sued Myanmar before the ICJ? I mean, it had nothing to do with Gambia, what happened in Myanmar, but it was an erga omnes obligation. So that's where maybe not the US, but other countries, absolutely. And that's where it's going to get interesting and juicy. The one thing I would say is that, and this takes me to the implications, I do hope that if there is, and there won't be a flood from tomorrow, let's be honest. I mean, it's going to be a trickle potential interstate case. But what I do hope is that they're done in a way that rather than provoking more tension in climate change multilateralism, they bring more ambition and urgency to the climate multilateralism. And that will need to be done in a very delicate, diplomatic way. International dispute settlement is a good thing, definitely. It's part of international law, but it has to be done in a way that is also very diplomatic. I'll stop there, Malgosia.
Thank you very much. Before I ask Kate to add, I would like to add that there are also obligations erga omnes partes, which are based on a treaty, and according to Article 48 of the Articles on State Responsibility, any party to a treaty can bring a case, and it was obviously confirmed by the ICJ in many cases now on obligations erga omnes partes. So this is yet another way to redress this kind of claim. Kate, please, your floor is yours.
Thank you. I just wanted to make a comment specifically as it pertains to the United States. I think that as an example, the United States currently is interesting from an international legal perspective because of the lack of recognition of international jurisdiction by certainly the current administration of the United States. And this is where we, I think, run into some of the challenges of international law from an enforcement perspective. But also where I think that the ICJ's advisory opinion and advisory opinions, all three that we've seen so far, can have a non-legal impact. And I think that is, it can help to begin a process of depoliticizing climate change, which I think is extremely important for any future action on climate change. Just some brief comments.
Thank you very much, Kate. I think we have time for one last question, I think. And maybe this is an interesting question from Professor Harro van Hasselt from Cambridge. I will read it out. Thanks for the great interventions on COP decisions and subsequent agreements. The 1.5 Celsius finding mentioned by Christina was contained in decision 1 SMA 5. That decision also contained several other important paragraphs on, among others, transitioning away from fossil fuels. Do you think that the court's ruling can be read to suggest that this part of the decision are also subsequent agreement for interpreting obligations in Article 4? This is a very complex question. I know I shouldn't, but Christina, what do you think, please?
That's a very interesting question from Harro, and I did read it in the chat. I think there's a difference between interpreting a paragraph in an article of the Paris Agreement, in this context, Article 2.1a, where we have the temperature, or the two temperature threshold well below 2 degrees and 1.5 degrees. And there had been a continuous debate, really, which one of the two is the relevant one. And here we have a CMA decision, which focuses particularly on the 1.5 degrees. And in this context was considered a subsequent agreement that looks at 1.5 degrees as the priority threshold, which is now considered by the court as legally binding. There is much more in the global stocktake decision 1 CMA 5, as Harro points to, including transitioning away from fossil fuels and everything else. I think this is not so easy to be considered a subsequent agreement. This is something that needs to guide parties' NDCs. They have to take this into account and needs to be reflected in the NDCs. But it wouldn't be quite clear which part of the Paris Agreement the other paragraphs in that CMA decision would specify as a subsequent agreement. I think this is particular for the reference to 1.5, in my view. Thanks. But thanks for the good question, Harro. Back to you, Malgosia.
Thank you very much, Christina. So I think, Ivano, we came to the conclusion of our session, I think. And I just want to say thank you for organizer, and very big thank you for all the participants with incredibly insightful comments and really making path for better understanding of all the advisory opinions. It was very illuminating and in-depth discussion. Thank you very much for the participation. Thanks.
Thank you all very much for joining us today. Thank you very much. Malgosia was amazing, great chair, as usual, Professor Fitzmaurice. Thank you to each of our distinguished speakers, really invaluable insights and thoughtful reflections. And I think there will be so much more that we will have in the next months to discuss together. And we are also very grateful to all of you in the audience for your presence, for your excellent questions you submitted. Unfortunately, as you've seen, you didn't enough time to address all of them live, but we will collect them and we respond in the event report, which we will find in a few weeks with the kind support of the speakers. So please, thank you again, everyone. Please stay tuned for this and for future initiative on climate change law and international law. Thank you again, and we look forward to seeing you soon. Bye-bye.